Good morning, everyone. I'd like to welcome and express my thanks to all those watching us in Brazil and other countries. I would like to greet our distinguished speakers, whose virtual presence really honors us today. And we should start the second day of this event. I had the pleasure to coordinate with Eric Moura, named Value Through the Legal Sector, which started yesterday. So in the first day of our event, we discussed commercial arbitration and dispute funding in two different panels. And today we will debate in the third panel, securities litigation and portfolios monitoring. And in the last panel, antitrust litigation. So now allow me to present to you Maria Eugênia Machado Junqueira, who will be moderating this third panel of our event. So Maria Eugênia is coordinator at Câmara do Mercado, B3, and she is a master's student at Lisbon University. So welcome, Maria Eugênia. Excellent event for all of us. Thank you so much. I guess Maria Eugênia she is just in a few minutes coming back. So I had, oh yes.
Sorry. Hello, everyone. Good morning. I just moved my phone, sorry. So thank you for the introduction. How Anna said, my name is Maria Eugênia, and I'm coordinator at Câmara do Mercado, which is the arbitration institution of Brazilian Stock Exchange, B3. I'm very honored to be here. And first of all, I would like to thank Anna Neri for the invitation and the opportunity to be here today with excellent speakers of a very trending and to speak of a very trending and important discussion in Brazil and US nowadays. And what we are going to talk here, how Anna said, is the current trends in securities litigation and portfolios monitoring, addressing some questions of these very experienced speakers who better than me may contribute with the discussion. On that, we have Michael Delangelo, Renato Tescari, and Fernando Merino. I'm going to skip reading the CVs to the interest part, but trust me, they are all high-level professionals. Before I ask some questions to the panelists, I'm going to share with you some statistics and relevant information about securities arbitration in progress at Câmara do Mercado in this moment, where we manage the cases arising from the arbitration clauses present in the bylaws of the most of publicly held companies listed in Novo Mercado and Nível 2 at B3. So for sure, most of the famous securities litigations cases from Brazil are under the rules, the arbitration rules of the Câmara do Mercado. Until today, the institution here scored the historical of 200 administrated arbitrations, which handled more than 40 billion reais in dispute. But it was from 2017 that the number of cases increased considerably. And this is mainly due to the growth of cases where investors sue companies for alleged fraud and omissions. On these cases specifically, we currently have almost 40 arbitrations in this moment that discuss the company controlling shareholder or members of the board directors liability. Among these cases, we have 3 collective arbitrations and yet some multi-parts arbitrations that have more than 100 or 1,000 investors as claimants. And these relevant security cases, there are several unanswered questions which our speakers will probably be able to debate here today. So I'm going to start presenting the speakers and then asking some questions. At the end, I think if the audience have some questions, please feel free to send on the chat. I think that it's possible. I wish you all an outstanding webinar, and I hope you can extract the most out of it. And thank you so much for the incredible panelists here today. So I would like to move on and welcome our first speaker, Michael Delangelo, as counsel former in USA that participated of numerous high-profile cases in class action regarding securities litigation, can bring to us the US perspective about the subject of the panel. So I would like to start asking you, what means securities litigation in US, and how do you counsel clients when they are deciding whether to become involved in securities litigation? You are on mute.
Yes. Thank you, Maria, and good morning. I appreciate the opportunity to be here today. I'm struggling with a little bit of a cold, so I hope you'll bear with me. I think that's an excellent foundational question for us to start with today. And so, speaking from the perspective of securities litigation in the United States, let me first provide a little bit of background that explains how we got to where we are today. The Congress in the United States began to regulate securities transactions after the stock market crash in 1929, which led to the Depression in the United States and which spread throughout the world. Following World War I, Congress determined that of the roughly $50 billion worth of securities that had been offered in the United States as of that time, approximately one half, or 25 billion, were completely worthless. It was determined that deceptive business practices and rampant fraud in the sale of securities prior to the stock market crash was the result of Congress's determination that about half of the securities in the United States at that time were worthless. This led Congress to take a sharp and hard look at the regulation of securities in the United States, and it enacted significant legislation to regulate securities markets and securities transactions. And that resulted in the two seminal securities regulation pieces of legislation in the United States that remain in force today and are the backbone of most securities litigation, at least at the federal level today. The first is the Securities Act of 1933, and the second is the Securities Exchange Act of 1934, which we refer to as the Securities Act and the Exchange Act, respectively. Both are extensive and complex, but in sum, both acts seek to provide investors with accurate material information, and that's a really critical term in the US system, material information about a security that would allow investors to make determinations about a company's risk, how to value the securities at issue, and to determine what's the proper rate of return for the risks that the investor is taking when it makes the investment. And Congress recognized that if investors were provided with inaccurate or misleading information, it would make it difficult or impossible for investors to make reliable assessments about those very things, the value of the security, the rate of return, and the risks. And so the Securities Act and the Exchange Act were designed with those policy goals in mind. Now, violations of the Securities Act or the Exchange Act can be enforced by the federal government or by investors through private litigation. And private investor-led enforcement of the federal securities laws have become an essential component to the regulation of securities markets. And this is not lost on anyone involved in the practice in the US. Our Supreme Court, in particular, has noted that meritorious private actions to enforce federal anti-fraud securities laws are, quote, an essential supplement to criminal prosecutions and civil enforcement actions brought respectively by the Department of Justice, some known to some as the DOJ, or the Securities and Exchange Commission, also known as the SEC, here in the United States. And kind of consistent with what I think people will hear in the discussion that follows about antitrust litigation, what we find is that the attorneys who bring these cases on behalf of private investors are referred to in the United States as private attorneys general. So, attorneys general being government officials at the federal or state level, and then when private attorneys such as myself and other colleagues in the bar lead private actions, we are referred to as private attorneys general. And the upshot is that Congress enacted these securities laws with the intention that investors would enforce the laws through private actions. And it provides investors with an express private right of action that allows any person who's acquired a security based on materially false offering documents to file suit under the Act. And the Exchange Act doesn't contain language that expressly provides investors with a private right of action. But since 1946, federal courts have consistently recognized the existence of what we call an implied private right of action under Rule 10b-5. And that's probably the most well-known aspect of the Exchange Act that relates to fraud action. And Congress has since recognized this in 1995 when it enacted the Private Securities Litigation Reform Act in 1995, that not only implicitly acknowledged that investors have the ability and right to seek private remedies for violations of the Exchange Act, but it fundamentally altered the manner in which federal securities laws were litigated. And so the PSLRA amended normal pleading rules to conform to civil fraud standards, although it included heightened pleading standards. And it also included something called scienter, or a culpable state of mind. That's a required element for imposing liability under 10b-5. And it requires plaintiffs to plead a particular fact that gives rise to what we call a strong inference that the defendant either possessed a motive or an opportunity to commit fraud. These would include things such as unusual insider trading, or other acts. Perhaps the company is about to go public or make a large issuance of additional shares, something that would provide a motive by the insiders to commit the fraud. And what the investor must do is set forth facts and circumstances that constitute strong, either circumstantial evidence of either recklessness or conscious misbehavior, or direct evidence if it's available. Although that can be difficult to acquire at what we call the pleading stage when the complaint is first filed. And critically, the PSLRA, again, the Private Securities Litigation Reform Act, requires plaintiffs to meet this heightened pleading requirements without the benefit of reviewing any information produced by the defendants through the discovery process, such as document productions or depositions. And so as a result, plaintiffs must often support their claims by facts that are developed through private investigations conducted by counsel, the government, or other sources. And so to kind of bring that together to your second question, when we're counseling private clients on whether or not to bring either a class action or a direct action, We're looking carefully at the size of their investment. Securities litigation in the United States is complex, it's expensive, and it's time consuming. It can provide tremendous benefit to the plaintiffs and the investors in a class, often recovering a meaningful portion of their losses. But if the losses are very small, we'll generally, on an individual basis, we'll generally counsel the clients to consider a class action, whereas if they're much larger, counsel them to consider a class action. And we also want to make sure that there's a firm belief that there's a foundation and that the investigation indicates that there is fraud of some material kind that matches either the Securities Act or the Exchange Act, so that we're bringing viable cases and not just bringing cases when a stock has dropped or an investor is unhappy with the investment, but where there's real fraud. Thank you, Maria.
Thank you. And next question, I ask if how are lead plaintiffs selected in USA securities litigation, and continue in some matter. What is the difference between a direction action and opt-out action?
Sure, I'll try to be brief because I know my prior answer was lengthy. Fortunately, the PSLRA, the Private Securities Litigation Reform Act, sets out a procedure for the selection of the lead plaintiff. And the process is very straightforward, and it is generally consistently applied across all cases because it's dictated by statute, which is generally not the case for other types of class actions in the United States. What the PSLRA provides is that when the first case is filed, the attorneys and the plaintiffs that file that case are responsible for simultaneously issuing a press release. And that press release needs to notify all other similarly situated investors that the action has been filed, to briefly describe the action, and also to notify them that within 60 days of the filing of that first complaint, that they too may file a motion to be appointed as the lead plaintiff. And what's unique about this process is that it does not require the additional investors who seek to be appointed lead plaintiff to file a new complaint or a new action. They merely file a motion, and that is sufficient under the statute to give them standing to be considered to be appointed lead plaintiff. And generally, the determination that Congress has set out as the defining factor really is which investor has the largest, what is called financial interest, which is generally translated to mean the largest loss. And we look at, you submit with your motion some details about your trading and a certification, and calculations are made on an accounting basis, LIFO and FIFO. And generally the court will make the determination based on the size of the loss. Congress and the PSLRA said there is essentially a preference. What the idea was is that more of these actions will be brought by institutional investors rather than individuals, on the theory that institutional investors make the cases more client-driven rather than lawyer-driven. I don't think that that is necessarily how things have played out. There are lots of cases that are directed by individuals and are not lawyer-driven. But at the end of the day, I think Congress's presumption was that the investor with the largest loss will take the greatest interest in leading the case on behalf of investors. And then there are some subsidiary things that I think we don't have enough time to really address, but about the adequacy of the plaintiff, the adequacy of their selection of counsel. But that's the general process the court goes through.
Okay, thank you. And what is being accomplished in a securities litigation in USA?
I think that there are three main things that the PSLRA has accomplished, and that the lawyers who are litigating these things under the PSLRA are accomplishing. The first is that the size of settlements has increased significantly, both from the inception of this litigation to 1995, and then really when the PSLRA was enacted, and then from 1995 until the present. There are lots of statistics available about this, but you can see this general trend, the size of settlements on a kind of relative basis is increasing, meaning that the litigation is becoming more effective, returning larger rewards for investors, and really enforcing fraud and making the litigation effective. The second thing is, while the amount of settlements are increasing, the amount of attorney's fees are decreasing. Again, there's a fair amount of statistics about this, but as contemplated, institutional investors and high net worth sophisticated investors do a very good job of negotiating sophisticated fee arrangements, and courts have also been cognizant of involved in that. And by lowering attorney's fees, you're of course increasing the return to investors. And lastly, there's been an increase in corporate governance reforms, which is something that's more difficult to achieve in individual cases, but certainly in class actions, lawyers have been aggressive about seeking corporate governance reforms as a component of the relief. And that has increased substantially since 1995 as well, and continues to this day.
Okay, thank you. Thank you so much for your contribution. In benefit of the time, I'm going to pass to Renato Tescari to bring the Brazilian perspective about the matter. I would like to introduce Renato Tescari, which with your experience as counsel in relevant Brazilian cases could provide the Brazilian view of the subject that we are discussing here today. Renato, can we start? I have one question for you, and some questions. And the first is, how do you see the current securities market in Brazil? And do you think that are some of the legal and political aspects that make securities litigation harder to take place in Brazil?
Thank you, Maria Eugenia. Before I'm answering to that question, I'd like to thank and to congratulate my fellow panelists, Fernando Merino, Michael Delangelo, you, Maria Eugenia. It's a huge pleasure for me to be here and to discuss these subjects. I'd also like to thank Ana Neri for the honorable invitation. I'm very happy to be here and to share with you the academic benches, and some difficult cases that we share in our profession as lawyers. But answering to your question, Maria Eugenia, I would say that at the same time, I am both, I have some uneasiness and some optimism regarding securities litigation and security markets in Brazil. And I will say why. First, let us be really straightforward. I mean, it's not that Brazilian companies are not committing fraud. They are, but it's just that Brazilian investors or people who are investing through B3 is just until now has not yet received a single dime in indemnification. So our market, let's say it's a developed market from about 70 years now, and it's been 20 years since the B3 new market was developed. And even though we have big trade numbers, the fact is, and we have frauds, the fact is the victims here just doesn't get any payment reimbursement for the fraud they fall into. So in theory, there's a study relatively recent from Dick, Morse, and Zingales showing that at a given market in any given time, there's a 14.5% chance of a company to commit fraud. And if we leave theory and go to the practice here in Brazil, for instance, we had at least, to the last time I checked, 17 Brazilian companies that were being sued in the United States, that were being or have been sued in the United States for securities fraud. And from these 17, 7 of them are one of the 20 biggest Brazilian companies. And they have been paying like multi-billionaire settlements to foreign investors, but we don't see the same thing in Brazil. I mean, a Brazilian doesn't get any share of all these settlements that is being signed abroad. Just by example, let's take the Petrobras case. Petrobras securities litigation case ended with a $3 billion settlement. So considering that just a small portion of Petrobras shares were being traded at New York Stock Exchange, if we are to apply the same proportional rate of indemnification to Brazilian investors, Brazilians should have been paid $6.25 billion in the indemnification, but until now, nothing has yet been received. So this is something that makes me wonder a lot about Brazilian current security markets. Actually, because Brazilian investors lose twice. First, when they lose the value of their investment after discovering a fraud, and second, when the same companies that they are shareholders or that they have papers pay multi-billionaire settlements to foreign investors, and which of course has impact in the company's values and the company numbers, and nothing about these settlements goes to Brazilian investors. So this is why, in my opinion, they lose twice. This gets a little bit more tricky when we analyze that B3 has been, as you may know, Maria Eugenia, is breaking records of people, of the number of people entering and adhering to B3. So for the past 2 years, the number of individual persons that decided to invest in Brazilian Stock Exchange has tripled from 700,000 people to 2 million Brazilians. So this is something that worries me, because although people who are investing in the stock exchange know that they have financial risks, they don't know the legal risks that they are facing, that if they were exposed to a fraud, they have very low probability to receive any kind of indemnification. But on the other hand, I'm also optimistic because the numbers you just showed us, Maria Eugenia, and some recent studies shows that this is an issue that we are currently addressing. So this is something that is under development. We are going after at least the latest of frauds. And this is something that, in my opinion, will increase a lot in the next couple of years. So the cases are arising. Some serious studies are starting to come out, and seminars, webinars like this are the way that we could provide more information and better intel for our courts, our arbitration chambers to decide on these matters. So if it's a bad thing that we lack experience in this case, it's also a good thing that we could start fresh and could start taking the right steps and going and following good examples like the US, like Japan, like other developed countries that have been going after these claims for, let's say, almost 50 years or more. So as to your second questions, as what are the legal and political aspects that make security litigation harder to take place in Brazil? It's hard to name one or twice. I believe, in my opinion, would be several. As I mentioned before, Dick Morrison, Zingales, in the same study that I mentioned before, they say that without a mechanism or a tool as the class action, securities class action that will be very well explained by Michael, without it, it's really difficult to pursue a securities claim, actually to detect fraud and pursue the fraud. And this has to do with both political and legal reasons. And probably this is something that interferes in Brazilian capacity to pay its investors. So for the political side, besides securities class actions, which is basically a private enforcement measure, there is also a public enforcement measure that could publicly enforce the shareholders' rights, which is basically led by CVM, Brazilian's SEC. And CVM and studies, international studies, shows that countries, civil law countries as Brazil, usually invest a lot less than our common law siblings in public enforcement of shareholder rights. And this is basically something that interferes and in the reach that CVM could get in terms of going after such frauds. Besides the lack of reach, it's also important to say that all the CVM procedures, and even when CVM finds out about the fraud and goes after the company, all the product of the penalties is going just to the treasury. It's not going to the real victims. So this is also a problem that should be addressed, and that a public enforcement of shareholder rights just doesn't complete. As Michael said before, private enforcement is one of the most important things when it comes to enforcing corporate governance measures, enforcing corporate governance legislation. And that's why we should focus on measures, on improvements when dealing with this kind of problems. And in Brazil, we can fairly say that our scholars would most part of them agrees that our main problems here lies not in our material legislation, but in our procedural legislation. So it's not something that we do not have the rights to pursue, or that we need legislation reforms to pursue these kind of claims, but it's how our legislation is being applied in the concrete cases, and what are the obstacles that we have in our procedure legislations that affects our will and the possibility to pay these affected these victims. So I would say that from the political side, these issues addressing the lack of investment in the CVM, and also one very important thing is that Brazilian government is a shareholder of Brazilian's biggest companies. So this is also some kind of problem due to all the lobby, all the power of Brazilian government in the courts and all this stuff that can interfere in how our legislation is being applied, together with a very, in my opinion, not well developed role of our institutional investors here, because let's say our banks, our funds, most part of the time have good contracts with the defendant. So it's also we also have a problem of conflict of interest when our institutional investors who are which are basically the most affected ones to go after the indemnification. So basically, this would be the main issues that I see right now, the main obstacles that we might need to pursue, whether to arrive even close to something that the United States has been dealing with.
Okay, thank you. The last number is 4 million CPFs in B3 in the last years. So probably these a lot of physical investors, I don't know how to say, will increase the requests for arbitration to respond to searching the company's liability for some fraud or omission. And to the last question for you, here in Brazil, we have any actions that are similar to 10b-5 as a US rule?
Yeah. Well, yes, Maria Eugenia, I totally agree with you that the increasing number of people involved in Brazilian stock market is probably going to increase in the number of actions and the number of lawsuits pursuing the company. But we have a big obstacle to pursue, which is basically, in my opinion, the mandatory arbitration clause, which the new market demands to be in the company's bylaws of any company that wants to trade their shares in the most premium lists of B3. So we have to take a good look into that, because I mean, this was first sold as a very important mean to ensure corporate governance in Brazil, and I'm totally on board with it. But right now, if we take a good look in securities litigation cases, we of course have big victims, institutional investors who have big losses, but we also have the great amount of people who have small losses, and that going after the company in an arbitration is just doesn't pay off, because they have to invest maybe 1 million reais, millions of reais in an arbitration in order to get just very few thousand of reais in indemnification. So, and in order to unite all these people it's a very great obstacle that I don't know if we are right now really prepared to face. Going up now to your question, we do have, in my opinion, a similar rule in Brazil, because for one side, we have mandatory disclosure and legislation that expressly states how precise must the information be when published to the market. This is something that we had, that has been in our legislation since 1850 commercial code. After that, mandatory disclosure and the disclosure of false and misleading statement became a crime in Brazil in 1946. And right now it's stated both in Brazilian law of corporation and Brazilian securities law, and also in some CVM regulation by the numbers 358, 400, and 480. So we do have legislation that states that that all the information published to the market must be complete, enough, and all those things that we know. But the main problem, in my opinion, which I totally agree with the main part of our scholars, is that we just have problems and we're facing issues to enforce that. And to enforce that, I would say that we basically need to pursue something closer to the United States, to American class actions, which will be either collective actions in Brazil, which is basically led by public office, but in the private sector, it would be from investors associations, and also by collective arbitrations, which are now being discussed, and class arbitration, I'm sorry, which are now being discussed and being the focus of great challenges, I believe, in B3 arbitration chamber. So I do believe we have something similar to 10b5, but I do believe we have a lot of obstacles to overcome. And from that, I don't think we need to reform our legislation. We just need, in my opinion, to address and discuss these subjects, because I think they're not being applied well enough.
Thank you, Renato. And I agree with you that the cost is a root problem to the investors today. And I think we are moving forward in small steps to class arbitrations, but we have to do a lot. Thank you for your participating. And now, finally, Fernando Merino. I think that how he is an attorney licensed both in Brazil and USA and US. He maybe can connect both systems and bring to us the company's view about securities litigation. So first of all, Fernando, I ask you if you do you believe any system, Brazilian or American, is better or more sophisticated when it comes to securities litigation?
Very good. First of all, good morning to everybody, and I want also to extend my compliments to the panelists I'm joined today, and thank Erika and Anna for the kind invitation to join this panel, this conversation. Let me start perhaps by saying, Maria Eugenia, that I think that's in a way an unfair question, because the US is by far the most sophisticated securities market, and also the deeper securities market that we can see around the world. And when we think about investor protection, probably there is no other jurisdiction that can compare to the level of sophistication that one has in the US. And to echo Michael's initial comment, which I agree, how at least in the US, securities litigation for minority shareholders is perceived as part of the administration of justice. So it's part of the system integrated together with regulators and the law, et cetera. And I think that's in itself a big difference. And we now see some jurisdictions such as Holland, the UK, and Germany that are starting to follow some of the steps that the US has long taken. That being said, I think it is a bit unfair to compare that with Brazil, where our own arbitration law is relatively new. And I, having spent 20 years as a general counsel for large companies in Brazil, and a number of years as a board member, I think there's been a lot of progress when it comes to private commercial arbitration in Brazil. Candidly, be it for securities litigation or M&A disputes or construction. So if you were to look at what was the type of cases where you would see arbitration in Brazil, particularly in the beginning, they will be mostly construction related. And probably still see a lot of those matters, but we definitely see now a number of contractual disputes, a lot of M&A disputes, and increasingly securities litigation. So I do think we have to look at each system and its own sort of peculiarities. I will echo some of the comments that were made earlier on, that when we think about individual investors in particular, there's much more that can be done in order to protect Brazilian investors. And by Brazilian investors, of course, I mean investors that acquired shares in B3, right? Because those Brazilian investors also include eventually international investors who purchase shares in B3 and on the basis of the compulsory arbitration provisions from Novo Mercado are required to arbitrate. So in that sense, I think it's not a fair comparison, as it would not be a fair comparison probably with a number of other jurisdictions, but I think we're moving in the right direction.
Thank you. And what is the current view of companies, law firms, and institutional investors in Brazil when it comes to securities litigation? Is there any sort of culture? Because here in B3, we have a big problem that to change the regulation, arbitration rules of Câmara do Mercado, we need the approval of the companies. So how do you see that the view of the companies in this moment?
I think that's an excellent question, Maria Eugênia. And look, echoing some of the prior comments that we had before in this panel, I think when in thinking about, and I was at that time working at JP Morgan as an in-house lawyer and actively participating in the process of creating Novo Mercado, I think that people really thought about governance at the time and an alternative solution to what was then perceived as a judiciary that did not necessarily have the level of sophistication or would not be in a position to, in an expedited manner, resolve issues. I don't think that most people envisaged at the time that that provision would eventually lead to what we are now talking about, securities arbitration in Brazil, and all the complexities that come associated with, in particular class arbitrations, right? I think when you're talking about large institutional investors are defending their positions, I think that's a slightly different discussion. But look, to that point, I think that originally companies thought about it as, well, if we need to litigate and resolve an issue, better to have someone that in theoretically should be better prepared and should do more about it. And it would be a confidential discussion, and it would be a more expedited process. It would take less time. I think now that increasingly the companies are aware of the fact that they will eventually need to get engaged in the securities litigation. We, of course, have seen a wave of litigation in Brazil because of corruption-related issues and Lava Jato, et cetera. But we have also had a number of issues that are related to accounting controls. That obviously we have some natural, not natural, but disasters such as the Vale case. So the nature of the fraud that is being alleged is also changing quickly. And I think that now most companies are fully aware that they ought to be prepared to defend themselves here in Brazil in case they face a similar situation. By the way, another topic that I would also like to mention is that I think we are seeing also, probably since the Petrobras settlement in the US, we are now seeing a much more active group of institutional shareholders, both international shareholders that are already into the practice or standard of litigating the US, not necessarily because they are seeking recovery, also for that, but quite candidly to discharge their fiduciary liabilities to their own investors. That's particularly true for asset managers or hedge funds, et cetera. And I wouldn't be surprised if we start seeing more of those institutional investors that have both ADR positions and B3 positions coming to Brazil and being more active in these proceedings. But also the other way around, which are the Brazilian institutional investors, including hedge funds and asset management companies that are becoming more sophisticated, and that will start to more often seek the US route, or for that matter, some of the European jurisdictions that are opening up. So I think there's an ecosystem that is developing that is far more sophisticated than anyone anticipated 10 years ago. And at least from my perspective, I don't, if I were to be again in a company, I would be very mindful about that and thinking about that. And again, it's part of running a company. Being prepared to engage in this type of litigation is part of running a company, particularly if you are an in-house lawyer.
Thank you. I think we have time to the last question. So feel free to speak more some issue you think is relevant. But I would like to hear of you. How do you? What is the value that you believe parties in Brazil may be leaving on the table when not acting upon potential rights?
That's also an excellent question. I will share my thoughts very briefly so that we can leave a little bit of time for questions to the extent that we have, or to an exchange between the panelists. So so that we can have a little bit of time left here. I think this will depend on the nature of the investor, right? Obviously, class actions in the US are designed to cover the whole class and thus individuals. And to the extent an individual in Brazil has ADRs or is entitled to participate in a class action, that's really, I think, just a question of paying attention and keeping informed about what's happening and being aware that this opportunity exists, right? When we start looking at companies or institutions that are in the business of managing someone else's money, asset managers and private pension funds, public pension funds, I think that changes a bit. And I think that question has really two answers in my mind. One is of an economic nature, and the second is of a legal nature. So let's start with the legal nature. A lot of these asset managers are subject to the obligations, fiduciary obligations vis-a-vis their investors. And we're not going to have time today or here to engage in a deeper discussion about that. But I think it's fair to raise the issue and for institutional investors that are managing other people's money to consider that, whether or not there is any potential violation of their own fiduciary obligations where they are not proactively seeking recovery on behalf of the members of their funds. And by the way, I'm not trying to say there is one, but I think it's something that had to be thought about and discussed and considered. And second, there's obviously the pure economic one. And particularly when a claim comes to the US, there can be substantial amounts involved, as Michael and Renato had already the opportunity to share here with the group. And there may be more economic upside than a number of these investors are realizing. There are, of course, costs, there's time involved, etc. But economically speaking, when all of that is factored in, some of these may present relevant investment opportunities.
Thank you so much, Fernando. I think we are on time. So I would like to thank you, all of you. And it was a pleasure for me to be here today. And I will give the floor to Eduardo Gaban, who is the moderator of the next panel. But I I'm at your disposal to speak more about these issues and about this subject. And it was very useful for me to be here today and discuss this subject with you. So I think Eduardo Gaban is here already. I'm gonna introduce him. Eduardo Gaban holds a bachelor's, master's, and PhD in law from PUC São Paulo, visiting Fulbright Scholar at New York University School of Law in Competition Law, Trade, and Regulation Program. In 2012, he founded the Nucleus for Studies and Research on Competition and Innovation at PUC São Paulo. He has founded, together with Professor Juliana Domingues, the Brazilian Institute for Competition and Innovation, and he is founder and partner of Nishioka and Gaban Advogados. Welcome, Eduardo. How are you? Thank you.
Thank you very much, Maria Eugenia, actually. It's an honor to meet you, to be part of such a amazing initiative from the Attorneys Institute of São Paulo, IASP, and share a virtual table with friends, long-standing friends, and pleasure to meet Mr. Patrick Madden. And I must congratulate you for the previous panel involving Renato, Michelle, and Michael D'Angelo, and Fernando. Congratulations, a great panel indeed. And well, I think we have an hour to talk about a issue that will cover age, I presume, and I will save everybody's time and present my co-speakers, starting from Mr. Fernando Furlan. Mr. Fernando Furlan is the former president of the Brazilian Antitrust Authority, CADE. He's a former chair of BNDES, among other public positions, and is very well known among us, the practitioners here in the country. So together with Mr. Fernando Furlan, we have Bruno Maggi. Bruno Maggi is the founding partner of Maggi Advogados, a firm specialized in antitrust and competition law in Brazil. And we have Mr. Patrick F. Madden. Patrick is shareholder at Berger, a Montag based in Philadelphia, highly specialized in antitrust violations, serving as counsel in numerous relevant U.S. class actions. So, and myself, who I represented. So, if I am not wrong, who would start this amazing discussion? It would be Mr. Patrick, right? And later,
yes,
followed by Mr. Furlan. Okay, all right. So later we can hear Mr. Furlan and then Mr. Maggi, and then I will make some interjection as long as they are intelligent interjections. Otherwise, I will stay quiet. Thank you.
Sure. So as I understand, we're talking about today, I guess, an overview of the American antitrust laws and enforcement mechanisms. We have three sort of types of enforcers. We have our federal enforcers, which is the Department of Justice and the FTC. We have state attorney generals that have their own laws and can also bring actions under the laws of the United States more broadly, either on behalf of their own purchases as a state or on behalf of their citizens. And then we have private enforcement mechanisms, both under the state laws and under the federal laws. As I understand it, the private mechanisms in the United States are far more robust than in Brazil. The majority of antitrust work done by the federal government, as I see it, is in the context of mergers and evaluating whether to allow mergers to go through. And as a plaintiff's class action lawyer, I'd say that for the most part, they let too many mergers go through. But that can also lead to cases for plaintiffs in the United States. So the way that the Department of Justice and the FTC, which are the two federal enforcers, sort of divide their work, is that the DOJ, the Department of Justice, is the only criminal enforcer of federal antitrust law. The FTC can do some civil enforcement, and the DOJ does some civil enforcement, but by and large, the FTC will refer criminal cases to the Department of Justice. And beyond that, they sort of just check with each other as to whether there's an open inquiry whenever they start something. The FTC will often focus on healthcare and pharmaceuticals and food and energy and certain tech industries, whereas the Department of Justice has sole jurisdiction over banks, railroads, airlines, and telecommunications. Their inquiries are usually confidential, although you will sometimes see in public SEC filings that companies will report that they are subject to an inquiry or a document production obligation from these entities. What we've seen recently is a more active set of state attorney generals that are bringing cases against, in particular now, large tech companies, primarily Google. Folks have seen that the state AGs and the Department of Justice have filed cases against Google for monopolization. And I guess I should step back and say that by and large, there are two kinds of conduct at a really high level that the federal laws aim to get at. And one is agreements and conspiracies and restraint of trade. That's your price fixing agreements. It can be exclusive dealing or tying allegations, market allocation agreements. Basically, anytime you've got competitors that are entering into an agreement, you're in this world of these conspiracies of restraint of trade. You can also have vertical agreements in restraint of trade. So those are a supplier agreeing with a distributor to do something that affects competition. But the horizontal agreements fall under sort of different modes of analyses. Aside from agreements, there are cases that concern monopolies. And so those are your large companies that take over whole industries. And that is what we are seeing a lot of activity by the state AGs and by the Department of Justice and the FTC in the tech sphere right now. So the tech has for the last 2 years or so been a real focus of all sort of levels of the enforcement mechanism. You have cases against Apple and Google for their stores, their app stores. You have cases against Google for their search, for their advertising. There's the FTC's case against Facebook. There's the state AGs in digital advertising and search. There are private suits against Amazon for ebook pricing and its third-party seller marketplace. And each of these cases focuses on what we call a Section 2 theory, which is the section of the Sherman Act, which is the federal antitrust law that prohibits the abuse of monopoly power. The willful acquisition and maintenance are the key terms. Beyond tech, more recently with our current presidential administration, there's a focus on what are commonly referred to as no poach agreements. And those are agreements between competitors, usually horizontal competitors. So as opposed to the vertical supply distributor relationship, not to poach each other's employees. We haven't really seen much in terms of governmental enforcement in this area, but we do know that it's an area that they have made a priority. And so by and large, most of the enforcement in that area has been done by private individuals, so employees who challenge the agreements. And then at all times, as far back as I could think of, pharmaceuticals have been a focus of both the regulators and private enforcers. I don't know if you have specific areas you'd like me to touch on sort of within these broad buckets that I've laid out.
Yeah, maybe we should maybe I should help you out because it's too broad the subject matter for you to cover, and we should, I mean, we should stay a day learning about the US, and then we would schedule another day to figure out how to apply to Brazilian reality. So I have two questions that may address your speech, and then we can hear Mr. Fernando and Mr. Bruno, and make it a little informal but more enjoyable for whom who is watching us. So I have three main questions for you, basically, Patrick. And I see that you have a huge experience in being a plaintiff in the US, right? And so we have at least three main topics here in the country that we are facing now in our damage claims. We have a damage system here, not as strong as the US, but we have it. And I have two questions about the system itself and a question about the drive it to attorneys, right? So now we have, I mean, I'm not sure how many lawsuits we have now, but we have like less than 50, if I'm not wrong, in the country, right? And they are pretty much centered in the main economic zones, in São Paulo area or Belo Horizonte area, or maybe in Brasilia area, the capital area. So and now we are facing in Brazil a very big hurdle, if I may, for the plaintiffs to demonstrate damage and to persuade judges to apply damages, right? We have another question about the amount of damages that I will leave for the second part. But how the US pursue the demonstration of damage, considering for example, a price fixing cartel nationwide, right? This is the first question. The second question is, how does plaintiff handle the risk for litigation in the US? We have a risk for litigation in Brazil. So we have a risk of up to 20, and in some cases a little more, over the value of the lawsuit that is driven to the losing party in the end. How does it work in the US? And the third question is, when we are in the early stages in the damage market for attorneys in the country, right? As we are in the São Paulo Attorneys Institute, REALM, we can talk about the market for attorneys. So we are in early stages. And now it's common for us to see firms working as plaintiffs sometimes, and sometimes working as defendants, right? Representing defendants, representing plaintiffs. And it brings a little a deal of conflicts of interest, right? How it work in the US in the early stages? So three main points for you. And then we can hear Furlan and Bruno. Thank you.
So under the federal law, which is primarily what I work under, there's 3 times damages for starting the 4 years prior to the filing of the lawsuit. And the way that damages are calculated depends on the kind of case it is. I deal primarily in class actions. And in a class action, you need to be able to prove that that everyone suffered damages in a similar way, such that you can calculate what the damages are. And so in a price fixing case, what you're looking at is an overcharge, or in the case of a buyer monopsony case, you're looking at an undercharge. And so what you're calculating is the difference between what you pay in the actual world with the conduct in effect and what you would pay if you were to remove the conduct. And so you engage econometricians to try to remove the conduct and look at what prices would be in what we call the but-for world. And so that's an expensive undertaking. And so when you're talking about what your risks are, it really depends, again, on whether what you're talking about is an individual case or a class action. In an individual case, there is fee shifting where you can recover the attorney's fees if you win as a plaintiff. But by and large, those cases are paid for, or at least on an ongoing basis, while they're being litigated by the plaintiff. In a class action, the plaintiff's firm will front all of the expenses and fees. So they recover only in the event of a settlement or judgment. There are litigation funding options with third parties. Those are used by some firms and not others. A lot of firms just fund these on their own, and by and large, that is what we do as well. And in terms of the conflicts of plaintiffs and defendants, I mean, there are firms that do both sides, that represent plaintiffs and represent defendants, and at times that really trips them up. You will see them taking positions on behalf of their clients that are adverse to the position that they have to take with another client. And as a primarily plaintiff's lawyer, I seek to exploit that. I look at the decisions and the briefs that they have written on behalf of their plaintiff's clients. And so when they try to say, this claim makes no sense, this theory makes no sense, you cannot do this, I look and I see that they have actually argued the other way and won. And so it's hard for them in that context. And as a result, I think what you see is, for the most part, firms choose a lane, and they either do almost all defense or they do almost all plaintiffs. And there's only very few firms that do both. And those firms are very high quality, and they have to be to walk that line.
Right. What do you think, Fernando? Have any comment on this? You're on mute. And I'm sorry, just reaching the protocol, I forgot to thank you, Professor Ana Luisa Neri, for this opportunity. She invited me. I was really glad to receive this invitation. Thank you, Ana. Professor Fernando.
Hi, Eduardo. Hi, Patrick. Hi, Bruno. I also would like to thank and congratulate the Lawyers Institute of São Paulo for the event and for the invitation. I was asked to make some comments basically on damages, antitrust damages, right? And I think that Patrick mentioned something that is common for Brazil and the United States systems, that is the challenge to prove the danum emergens and the lucrum cessant, right? In any damage, antitrust damage case. But anyway, I would like to bring to our attention two articles of the Brazilian competition law that I think are crucial for understanding how the Brazilian authority, the Brazilian system, deals with antitrust damages. One is Article 33 of the competition law, and I'll read it very briefly. Companies or entities that are part of an economic group, in fact or in law, will be jointly and severally liable when at least one of them practices an infringement of the economic order. So here we have the first article in our in our competition law that clearly states how the competition law and the competition authority understand the importance of liability in antitrust damage cases. So the spirit of the law, the spirit of the competition authority also is to bring strict liability even for the parent companies. So one important thing here is to understand what is the influence that a parent company or any related party have in the, let's say, day-to-day business that is being investigated or eventually condemned, sanctioned by the antitrust authority. So we have to be careful with concepts like joint or common liability, and what is economic group itself. For that, we have to make a relation with the mergers and acquisitions aspect of the work of the Brazilian antitrust agency. So we have a resolution number 2 of CADE from 2012 that explains what would be an economic group for Brazil and how the liability and the responsibilities go through and within the economic groups. So it is well established in Brazilian competition system that a parent company or a significant investing company in another group, in another company, you have the competition authority has to prove either a direct involvement in the practice or the control or the ability to significantly influence the decisions of the company that is being investigated. So, in conclusion, these relating to Article 33, the spirit of the law and the spirit of the Brazilian authority is to really give strict liability to investing companies. For example, resolution number 2 that deals with mergers and acquisitions states that if a company invests 5% in a vertically or horizontally related company, this constitutes already a economic group. So the Brazilian legislation and authority are very strict pertaining the economic group concept. Very briefly on Article 47, that is another article of the competition law that deals with private enforcement or private litigation that is not as well as developed and established as in the United States, for example, with the treble damage system. Here in Brazil, we're still in our first steps on private antitrust litigations. Anyhow, Article 47 of our law, in my perception, aims exactly at giving more broad interpretation for these concepts. For example, the Article 47 reads as, those harmed may go to court to, in defense of their individual interests, obtain the cessation of practices that constitute an infraction of the economic order, as well as the receipt of indemnity for losses and damages suffered, regardless of the investigation or administrative proceeding, which will not be suspended to the filing of an action. So Article 47 also is very broad because it says, independently from the result of the antitrust investigation within the competition authority, a private party that may be damaged by another party's conduct, it may go to the judicial courts directly to receive any kind of indemnity. So we see here that the spirit of the law is really to try to be the broader as possible. Well, Eduardo, I think those are my first comments. Thank you.
For sure. You tackled, I mean, the most important issues that we have. Basically, we have a well written law. The language is well written to find people or companies guilty under the administrative sphere. However, it's really not ready to pursue damages, because we should be able to prove damage. So I have other 3 questions for you, Fernando and Bruno, but I would like to hear Bruno about this very first discussion. What do you think, Bruno? Do you have some words to say?
Yes, for sure, Eduardo. Thank you so much. It's a great pleasure to be here with you. I'm glad to be invited by Ana and by Eric, and it's an honor to speak with Patrick and Fernando for sure. Regarding the damages in Brazil, we are, again, I'm not willing to repeat what everybody said, but just to add some impressions that I have, considering all the parts I have here. But considering the damage, for sure, we have the same difference that Patrick spoke about in US. Here in Brazil, considering the difference of the class actions and the individual lawsuits. Actually, here in Brazil, we can divide in three different situations. And I think Eduardo is very updated to the information about the lawsuits in Brazil, because IBRAC, that's an Institute of the Competition Lawyers here in Brazil, just published I think last week or 2 weeks ago, the very updated study to which I contributed of the lawsuits in Brazil. And indeed, we have among around 50 cases when we consider the individual cases. We tracked 40, actually, individual cases in Brazil, 3 class actions that in our case, they are called ações coletivas, collective actions that are very similar to the class actions. And we have more than 50 ações públicas, ações civis públicas, that in English is like a public case. It's not similar to the class action. It's something that here in Brazil, it's an initiative from the public prosecutor officers, and they seek for a broader indemnification for the society in general, not for individuals exclusively taken. And then putting all together, we have around 100 cases in Brazil, but considering only these individual and class action cases, we have around 50. It means that we have a very complicated situation, because for these public cases, it's another a very different situation, because we need to, similarly to the class actions, we need to have a first decision implicating the percentage of the overcharge and the general standards of the damage. And then after all, every consumer or popular that seems to be damaged by injured by that infraction need to start his own lawsuit based on that prior decision. But then we now have the liquidation very separated from the first stage of damage and overcharge definition. Considering the individual cases, it's different and maybe easier, because we can do all together. The judge can do this separately, as in the class actions. It means define the standard and the overcharge in general, and then in the second stage of the process, the execution and the liquidation will be made in a separated phase. But actually, it's all regarding a same company, a same injured person, and then this is easier because you don't have any other discussions in the second stage of liquidation. This is what we have, and for sure, we are still running to have a very good decision in Brazil about damages, because when we talk, and Furlan said something about that, when we talk about damages, we need to say that we have different positions for emergent damage and loss of profit. For sure, in Brazil, loss of profit, in my view, it's something that we can seek many years after in the future, because it's much more complex. Now, if we are seeking only the damage, the emergent damage, we are lucky if we can get it. And the best thing is try to get the direct emergent damage. Because when we are trying to say about reflex damage, indirect damages, or loss of profit, all of this for sure is something that relies on the cartelists and all the any other infractions, but the victims are not ready to look for it in Brazil, I think. I mean, the victims can look for it, but the judges, the judiciary branch is not ready to decide about that yet. And just reinforcing what Furlan said, not only the competition law says about solidarity, but when we look at the civil code, the article 942 says the same, states the same, that everybody connected to the same injury or the same cartel in this case is liable to pay all the damages. And then again, the civil law and the Brazilian law, the competition and civil law are very strict. We just need to wait for this development of the civil, the judiciary, and definitely to succeed on trying or establishing a method or something like how to define the indemnification and have some methods to make it easier for the victims. Just to finish talking about the conflict of interests, I think, and this is just, we cannot predict the future, but I think we will be closer to Europe than to US. It means that the US market is very big, and I agree with Patrick that it's very difficult for a US lawyer to be in both sides. And this is what we see in Brazil now. In my case, I worked many years for the cartels, for sure, because it was what we had in the past. But there are more than 5, maybe 10 years that maybe 8 years that I'm dedicating only for the defendants. Sorry, to the plaintiffs. And then I cannot act for defendants now. I think this will change in the future. Maybe we will be closer to Europe, that the market is smaller, and maybe we will not have space for a full dedication for only defendants or plaintiffs here in Brazil as you have in US. But this is just a prediction. I think we will be in the future, probably we can act for both sides, for sure in different cases. But now what we have is similar to US, a very divided market when the plaintiff defendants are not talking. Plaintiff lawyers are not talking to the defendant lawyers. Sorry.
All right. Well, thank you very much, Bruno and Furlan and Fernando. And well, passing to another level of this discussion, I have a question, 2 questions to all, actually. We have it's not the same name, right? But we have sort of a Illinois brick doctrine in Brazil in force as a rule. And just to recall, this doctrine says that only the actual victims could pursue damages against the aggressors, right? And this is in practice tells us in practice that only if I'm able to prove that I suffered the overprice or I pay double, if I'm talking about I pay less, actually less than I should receive. I received less than I should receive when I sold or commercialized the product. If I'm talking about monopsony or oligopsony, I'm able to pursue damages, right? So how do you think we should, in practice, structure a case in a way to avoid this defense, this passing on defense? Well, how would you, Patrick, would you advise a client, and you, Bruno, as well, and Fernando as well? How would you handle this situation?
So I think I'm understanding the question, and it sort of gets at what in US law we refer to as antitrust injury. And antitrust injury is distinct from just a generalized injury, because you have to have been injured by the conduct that's anti-competitive. And there's this phrase that judges and defense lawyers like to throw around, that the antitrust laws protect competition, not competitors. And it's both a meaningless phrase because it doesn't really tell you anything about what antitrust injury is, but it's also one that you need to think about when you're advising clients and bringing cases. And the idea is, in an overcharge case is very simple. If you pay the overcharge and that overcharge is caused by a price fixing agreement or exclusive dealing or tying, then you have antitrust injury. So then the question is, are you a direct purchaser? In the United States, federal law only covers direct purchasers, people who purchase the product or service directly from the entities that are involved in the anti-competitive conduct. We also have state laws that allow you to bring indirect claims. So if it's in California, which is one of the big ones, California, Florida, New York, they have statutes that even if you are buying from a distributor and the conduct is taking place at the manufacturer level, you can still bring that case. So, and you're entitled to the entirety of the overcharge at that point. You're still not dealing with a pass-on defense. In my practice, I don't do a lot of indirect purchaser cases. There are some allocation issues between various kinds of indirect purchasers. So there's a big broiler chicken purchasing case in Chicago right now, where you've got grocery stores who are purchasing from distributors. And so they are not direct purchasers because the conduct is taking place at the processor level, who then sell to distributors, and the distributors sell to the grocery stores. So the grocery stores and the consumers who eat the chicken, or the restaurants and the consumers who eat the chicken, have separate claims that are in conflict of each other because they're battling over who's really paying the overcharge. But between the direct purchasers, the distributors, and the grocery stores, there isn't that kind of conflict, because the state laws that allow an indirect purchaser to bring an antitrust claim entitle that indirect purchaser to the entirety of the overcharge.
All right, Fernando.
Okay. All right, so just a minute. Well, I think here we are discussing also the standard of proof in a antitrust damage claim, and this is a very sensitive question, because very sensitive issue, because it's most times quite difficult to have, you know, a key proof to make your case. So I think in antitrust cases, most jurisdictions, and I think Brazilian jurisdiction also goes that way, or at least they should go that way more often, is that the standard of proof required when you have when the infringement, when the antitrust conduct has been proven, has been determined by the antitrust authority, then the antitrust authority should, you know, flexibilize the standard of proof required for demonstrating and quantifying the losses. Because if they don't do that, we are maybe allowing the offenders to benefit from the confidentiality of their conduct. So I think that's something that antitrust agencies should accept and work with, quantification made through inferences and reasonable estimates.
Nice. Thank you, Fernando. And just to make a little more spicy before Bruno interjects, considering in terms of numbers, so Bruno recalled, I did not recall, but thank you for that. We have like roughly 50 cases ongoing, 50 lawsuits, right? But if I'm not wrong, none of them involve direct purchasers. Is that right, Bruno?
Actually not, Eduardo. We have actually, your question is quite impossible to answer in Brazil, to tell the truth, because we can consider or not in the cement cartel, we can consider direct consumer purchases because most of the cases that we have against the cement producers are proposed by construction companies. Then they are the direct purchasers. Considering the gases cartel, somehow we can consider it sometimes direct purchases, sometimes not, because we are talking about hospitals, and it depends on who pays the account. And when you are talking about the Forex cartel, they are direct consumers, although they are not the direct purchases of the goods. I mean, the companies are not in the end of the supply chain for any of the goods that they sell, but considering the relationship with the banks, they are they can be considered as consumers somehow, but definitely they are in the last chain of the consumer chain, but also the first, because there are no more chains when you consider a forex agreement. But anyway, I think that your question is very good, Eduardo. The second, because it's a little bit easier to answer, but the first is totally difficult here in Brazil. It's a very good question, but I don't know how to answer. How to prevent the passing on the fence is very difficult, because in Brazil, we are not so smart as the US legislators, and we do not make any block or any supposition. Actually, our civil law don't allow any kind of restraint when you can prove, as Furlan said, we need to prove the link between the damage and the injury that you suffered and the action. It means that you can prove anyway that you have the link or you don't have the link, talking about the cartelists. And the only way I see to prevent on passing on the fence is to make a vertical integration on the market and to start a lawsuit in the name of every chain of the supply chain. Otherwise, you always have this discussion. Economic experts can assist the lawyers trying to review or to fix maybe a limit of money that can be passed to the next chain, maybe considering the characteristics of the market that you have below of the affected market. You can say that maybe it was impossible to pass the damage, or you have a limit of passing on the damage because of that characteristics. But in the end, for now, we have a new law under analysis by our Congress, but for now it's difficult to limit this defense considering the present law.
Thank you. Please, sure.
I just wanted to jump in. Fernando, I thought made a good point about the difference in standards of proof for damages versus liability. I mean, in the United States, there's a relatively high burden that you're going to have to meet to show liability. But then the way they look at it is, and this isn't really on whether the damage is linked to the conduct, but it's about quantifying damages. The way the scholarship and the courts look at it is, if you've proven that they did the conduct, that they performed the anti-competitive conduct, they do not hold you to the same level of burden and specificity when you're calculating damages, because to do that would be to reward the bad actor for making it impossible to precisely identify what the but-for world would look at. And so I just wanted to flag that sounds like it's the same in Brazil and in the United States.
Yeah, maybe you could share with us, Patrick, what is actually considered a direct purchaser? I mean, is it the consumer, the end user, or it can be like the supplier?
It is usually a business that is a supplier. And it's gotten more complicated in recent years because of a decision that we had against Apple, where there were consumers suing Apple for the charges that Apple charges developers of apps in the App Store. And so consumers are buying it directly from Apple, but the charge is being made to developers. And it created this situation where there was a question of, are consumers direct purchasers, even though the developers are the ones that are paying the overcharge? And the court ruled, well, if Apple's the one engaging in the conduct and consumers are purchasing directly from Apple, they are direct purchasers. And that's ultimately what you're looking at. You're looking at who is paying who and who performed the anti-competitive conduct. So if manufacturers are conspiring, then you need to be purchasing directly from the manufacturer. The plaintiff needs to have paid the manufacturer directly, not bought from a distributor or a store. So it is sort of the opposite of a consumer. It is usually going to be distributors. In pharmaceuticals, it's the wholesale drug purchasers, not the individual who uses the drug. In chicken, it's the distributors and sometimes the large grocery chains that are the direct purchasers, and not the restaurants and the consumers who eat the chicken.
All right. So Bruno and Fernando mentioned the law here, and the law limits on the law and the judges. And I prepared like a small play here and to all. And imagine you are the legislator, right? And we know that there are some, not many, some bills, some project of federal laws on the way, but they are still projects. They're not laws so far. So imagine Fernando and Bruno, and if you may, Patrick, you can jump in. Imagine you are the legislator, right? And all of us are agreed that we should have a strong antitrust damage system in the country. I do believe we should, you know. I do believe we should have the threefold system: the criminal one, civil one, damage, and the agency or the administrative one, right? So imagine we are the legislature. And I would like you to consider three hypotheses, right? What if the agency, we can change the law, renovate the law, and put a task to the agency, to antitrust agency, when deciding cases and finding people guilty, or companies or individuals, they should, as long as they can, as much as they can, measure damages in the decisions, right? It will not be the check, you know, the credit itself, but it will help. At least help. Imagine we could put this task to the agency. In the second one, imagine we could include an incentive for the candidates of a plea bargaining. I mean, it may be leniency or the like, for them to help to measure damages. I mean, as a standard, right? And in exchange of reducing a third or a little more, what they should give back to society as a result of their practice. They are self-reporting, right? Imagine that we can suggest it we can include within the law. And third one, imagine that we could create a specialized court. Would it be better for all of this?
Eduardo, can you repeat the second question, please?
What if we include inside the leniency program or the plea bargaining program, making it a little broader, an incentive for the candidates to identify the overcharge, for example, to suggest, to teach the agency how the cartel, for example, the conspiracy worked and what was the standard to raise the price, and in exchange of being covered in the leniency package or the plea bargaining package, in the civil side as well, because they are not covered at all nowadays, but they will, not paying zero, but let's say, they can give back to society a third of the money that they obtain with the wrongdoing. That's the second question.
Thank you. Hello, Patrick, you want to start?
Sure. I think I have the most thought on that second question. So much of the anti-competitive agreements and conduct that we see in the United States is discovered because someone has loose lips and says something. And the more that can be done to identify that kind of secret conduct, the better. I mean, some of the biggest cases that have happened are because someone reported it to the Department of Justice or to the FTC, and then it just spilled out into years and decades of litigation over the conduct. So yeah, it's an interesting idea because companies still get sued if they get criminal leniency by private plaintiffs, and they still have to pay money. And if there were a way to make them still pay for their conduct, but perhaps avoid the decades of litigation, you might actually see more companies come forward and more of this kind of conduct exposed and then remedied. And that's the kind of thing that I think has an interesting angle to it from a societal benefit standpoint.
Okay, Bruno, you want to be the second?
Yeah, sure, for sure. Actually, the suggestions are all good, but I can say that theoretically speaking, I could take the first one. That is to have all the damages and to receive, if the agency can estimate at least the overcharge, it would be much better because it can not only incentivize the victims to start the lawsuit, but also to give a guidance to the judges to how to decide. But thinking on practical approach, the second option that Eduardo said, I don't know if we can take all the three, Eduardo, but if we can take, I take the three. But if we need to choose the second, considering all that Patrick said, I think this is also applicable in Brazil, because the incentive is also much better. The incentive to that company that is not, that is still hidden, and the incentive to make the cartelist go to the authority and say something, and then we can find out the illegality, is the best approach, I think, anyway in the world, and here in Brazil for sure. It would be much better to have more cases with the incentive to have some results to the society than to just have a decision of the agency. But if you can take the three, I think they are all good.
All right, Eduardo, so my turn. I think the first suggestion is really good, rather difficult, because I'm not sure CADE will have enough resources to do that. For example, I think that should be greatly, it would greatly ease the lives of the judges that are going to take care of the cases, because if a specialized agency as CADE is going to prepare the calculation of damages, that is much better for the judges. But I don't know whether CADE is willing to do that, and if they have resources for that. For example, if CADE has its Department of Economics enlarged, maybe they could do that. Second suggestion is create incentives for lenients to identify or help to calculate the damages that they themselves have caused to society. That would be also very good, as my colleagues said. But I think the difficulty I find is that I find it quite difficult for the lenients to find it more interesting for them to identify the damage that maybe that identification may lead for much bigger damages, and then it's not on their interests. So I don't know whether what they're going to get from the state as a benefit is going to pay back what they're going to maybe face in private antitrust litigations based on the damages that they have themselves identified. And the third question is a very good question, an issue that I like. You know, I have written a small book about that. And I think by all means, specialized courts in antitrust and other specialized economic issues is very, very beneficial, not only to antitrust system, antitrust legislation, antitrust enforcement, but also for the judicial system, because we're going to, for example, it's more important specialized judges in the first instance judges, the judges that really deal with proofs, you know, the constitution of proof. This demands a knowledge of the specific laws as competition law by the judge. The second instance, the second degree judge, they may be more, let's say, general judges, but the judges in charge of constituting proof, they must be, I think, more specialized judges. Thank you.
Thank you. Amazing, amazing. Bruno,
if I can add,
yes,
I can just add something, Eduardo.
Sure, go on.
With Fernando, because if you don't have the specialized courts, it may be useless to have the first inclusion that you said, because what we see in the real world nowadays in Brazil is that even when you have an expert opinion and a very big economic study, it doesn't matter if it came from a very high expert or from CADE, the judge, since it's not specialized, maybe he didn't believe in the case, don't believe in the expert opinion or don't understand. But again, and just to conjecturate a little bit I heard and attended many meetings with this discussion with at least with the São Paulo court. And the problem is maybe similar to what you said to CADE making the studies. There are so few cases, we can have more, but the judges deal with thousands of cases and they don't expect that we can have such a number of competition cases in the courts. And then again, the problem is the money and how to support all these specialized courts. But again, since we are just conjecturating, we can take all of them, and Eduardo will also give us money for the economic department of CADE to have more people, and then we can do everything.
Sure. Well, for sure. The idea was a kind of role play, and you may choose the three, you know. The idea is how to make the system more effective. And of course, it's not easy. It's not an easy task for sure. But maybe changing the incentives, we could raise a lot the efficacy of the system, right? And just to answer to Fernando, maybe I was not clear enough, but the idea is that I suggested for us to play with is the including the possibility of the candidate, as long as they identify how much damage they caused to society, they would pay like a third as a recovery, you know, and they will zero more liability whatsoever. By the way, it somehow happens in the anti-corruption system in Brazil, right? It's not well written. It's a kind of mess nowadays, but in practice, this is the idea underway to limit whatsoever the liability of the self-reporters, but they always should pay, and not everything, but they should pay like a half or a little less, and then and in relation to what they disclose and the ability they give to the authorities to recover more, But it's, we just played. But I'm enjoying a lot this panel, and we have like 3 more minutes, and I would open to you guys to say whatever you want, and maybe we can follow the original line, Patrick, Fernando, and Bruno, and just say thank you very much for your time. I enjoyed very much.
Yeah, well, thanks for having me. I'll start with that. And I guess the one note I have from back towards the beginning of this discussion, you had mentioned something about loser pays. And I wanted to clarify on American law, we do not have a loser pays system. So that further encourages plaintiffs who may have a substantial recovery based on a novel theory or something along those lines to test it. You have to pay your own fees, and I focused my earlier response on how plaintiffs pay their own fees, but defendants are going to have to pay their own, sort of irrespective of the result. I mean, there are some mechanisms if you bring a bad case and a frivolous case and those kinds of issues, but on your typical case, it is loser pays. It is not loser pays in the United States. Everyone pays their own fees.
Great.
Okay. No, I just would like to say that I'm really happy to hear from Bruno the amount of private antitrust litigation in Brazil. So I think this is something that we all worked for. I remember the vote I gave as CADE commissioner in 2010 or 2011, I think, on the oxygen cartel, and I remember that I wrote in my opinion, I don't know, maybe 2 or 3 pages on how important private litigations in that case would be, because this is something that Brazil was missing, increasing private litigation as one of the pillars of antitrust enforcement in the country. So I'm really happy, and I'm really happy about this webinar, this seminar, because we're discussing this. We're discussing civil and private litigation, antitrust litigation in Brazil, and I'm really glad that to hear that the numbers are that high, which means it's not good because we are having a lot of antitrust cases, but on the other hand, it's good because this is common for a market economy as Brazil. The good news is that we are using private litigation in order to enforce antitrust in Brazil. Thank you. Thank you also for your words, Furlan, and thank you all. I just want to thank you everybody here, and this discussion was amazing. Eduardo, the questions are incredible, and for sure the contributions that we have from Patrick and Furlan helped me to be the third in line. Always is easier because we can clue and can take some impressions from the others, and in this case they are professors to me. So I would just want to thank you all for the contributions, and to see, it's very glad for me to see that this field of antitrust litigation is increasing and generating so many interesting discussions. I wish we can keep discussing, and wish we can have somehow similar market that Patrick have in US, maybe in some years. Thank you all.
All right, thank you very much, everybody, and who's watching us. It was a pleasure to me and to everybody who's speaking now. To have you with us, we had an audience of like roughly 150 persons. It was amazing. Thank you very much, and have a nice day.
Bye-bye, everybody.
Bye-bye, thank you.